I don't think we're going to figure this out on the fly. It sounds like you're in custody on a bondable amount. I think what we'll do, ma'am, today, I'm not, well, at this, so where we are procedurally here is that probable cause has been found, and enough for a warrant to issue. I want to address this identification issue though. So what we'll do is, I also don't want to interfere with your right to a speedy trial. So I think what we'll do today is, we'll go ahead and we'll commence today with the arraignment. So that will start your speedy trial clock, because I don't want this issue to interfere with that. But rather than set a pretrial hearing out like we usually do, I'll go ahead and set a review hearing since it sounds like you're in custody on another hold. We'll set a quicker review hearing for early next week to give the attorneys a chance to maybe sort this out, and make sure that that's all resolved. So what we'll do, ma'am, today is enter a plea of not guilty to the charge of criminal trespass. Appoint Thurston County Public Defense to represent you. Impose, I'll just do the warrant amount, $1,000.
Your
and
Honor,
then set it for.
can I just point out that I'm sorry, I didn't mean to cut you off. If you're still going.
Oh, that's all right. I was just going to say we'll set it for a review hearing rather than a pretrial hearing. Let's do that on Tuesday the 28th. So we'll do that right away at 1:30.
Your Honor, I've been in conversation with Bill Starnes, Ms. Kilgore's attorney, in her felony matter, and it's anticipated that will be resolved by Monday. So does that mean that Ms. Kilgore would be held in custody even after the resolution of that case?
Yeah, we'll set it for Tuesday. I mean, I think at this point we can't set it for Monday. We try to reserve that for new arrests over the weekend. It's bondable, but
I don't have any money. We're homeless. And I'm already been in here for over a month. I'm supposed to be getting time served on Monday for my other charges.
I'll go ahead and yeah. All right. So I'm looking at, okay, I've got Hannah Smith in front of me.
Miranda W. Kilgore with 2 L's and M-A-R, not I.
There's a Lacey. What's that case number?
It's Walmart.
58057. Okay. Oh, there we go.
But the case I'm in here on was in Little Rock. The case in Lacey was resolved already.
Yeah, I see that. You're on a deferred sentence. All right. Miss Wills, they have a position. I know I talked about bail there already, but
Your Honor, at this time, state has no objection to a release on the personal recognizance. Given the strange nature of where the complaint is at this time, I don't think it would be fair.
Yeah, I agree with Mr. Concur. I know you raised this first, and DPA Will sounds like is in agreement. Frankly, between the two names we have in front of us, if someone was trying to kind of pretend to be someone, it would probably be Hannah Smith, given her record, and then Ms. Kilgore here has got in on the felony and has a deferred sentence. So I take that as an indication of veracity, frankly, that Ms. Kilgore's correctly identifying herself. So we'll go ahead and do that, ma'am. We're still going to do the arraignment. Oh, go ahead,
Our
Mr.
request is for nominal bail in the amount of a few dollars to ensure that that Ms. Kilgore is receiving credit for time served during the period in conjunction with her felony case.
All right. I'm going to just go ahead and release her so it's not complicated. And that's whether someone's held or not. That's always up to the sentencing judge. There's no automatic grant of credit for time served. So, I mean, the attorneys at sentencing can sort of make a record about what happened here. It sounds like, Ms. Kilgore is saying they don't have a lot of money. I'm going to release you at this point and let your attorney, you've got public defense representing you, kind of make a record about your time in custody here. But that's ultimately up to the sentencing judge anyway. All right, so we'll release you, ma'am, and then we'll still do the arraignment. So the arraignment for today's purposes will start your speedy trial clock. So we'll still enter that plea of not guilty, appoint counsel, and then since you'll be out of custody, I think maybe what we'll do instead of set a quick review hearing is we'll go ahead and set a pretrial hearing instead, but I'll still set it out relatively quickly. Let's do. All right, so you're saying, ma'am, on Monday, your Superior Court case, you anticipate that resolving in a time served?
Yes, Mr. Starnes
situation,
says
so
I'm
you
gonna
won't
do a change of plea and be taking the mail theft and the trespass as guilty, and they're gonna drop the other charges, the charges on Marvin, and release us both on the 27th.
All right. Okay, so what we'll do is I'll set a pretrial hearing for you, assuming then you're out of custody, on August 19th.
Okay.
All right, that's going to be at 8:30, and that's going to be for a pretrial hearing. So, yeah, rather than do a quick review hearing, since you'll be out of custody, we'll just go ahead and let you connect with an attorney, let your attorney then talk to the prosecutors, see if we can figure out the identification issue, and then we'll be back in about a month for that pretrial hearing, understanding you'll be out of custody then.
Okay.
All right. Conditions of your release will include to not commit a criminal offense and to have no contact with, what's the alleged trespass location?
Something on 5th Street.
It's the same one, 6829 5th Way Southeast.
That was Olympia Street address, if I recall.
Yes,
Okay.
98503.
All right.
What was the address again?
It is, and you're going to get a copy of it there at the jail, but it is 6829 5th Way Southeast in Olympia.
Okay.
And
thank you.
there at the jail, you're going to get a copy of a judgment sentence form showing that you're released on the trespass charge, on conditions to not commit a criminal offense, have no contact with that address, which you'll get a copy of, and your next court date, which is August 19th at 8:30.
Okay.
All right. Well, thank you, ma'am. I appreciate your patience in working through all of that. You've got an attorney from public defense who will hopefully help you figure this out and represent you in negotiations with the prosecutor. Well, I'll start with Ms. Will. Is the state requesting bail for Mr. Schubert?
Give me just a second to take a peek at his criminal record here.
I believe it's in the judge's folder. Let me know if I've done that correctly.
All right, let's see. Yes, all right, thank you for putting that together.
At this time, state is unaware that Mr. Schubert has any other criminal history in the state of Washington, and given the nature of the charges, state doesn't have any objection to a release on his personal recognizance.
Okay, thank you. And I think that under 3.2, I agree. The only thing that might raise concerns is the nature of the charge and the underlying allegations, but I think that's in my view the weakest factor as it runs up against the presumption of innocence and the presumption of release. I do think, though, the PR release, it would be appropriate to subject that release to a DCR review, given the nature of the allegations there. So I'll condition his release on review from a DCR professional. And then, all right, so we'll do that. And I've got the 1077, so it's one thing at a time here. I'll take a look at the 1077. All right, I think, so this may be a situation, Ashley, where we got to print this. All right. I know it's kind of an unusual kind of in the moment filing here, but it's a PDF, so we'll print this out and I'll sign it. The 1077.
Oh, yeah. I mean, I'll put that in the best form.
And it looks like Mr. Schubert's JNS is also blank. Thanks. All right, so on the 1077, we'll do out of custody evaluation. And we'll immediately go into excluded period under the competency prong. $10.77. Are we able to get a JNS for? Yeah. Looks like the one that we've got is blank. Oh, yeah. All right, and then what we'll do is we'll set a competency hearing. I know it's unrealistic after 3 months, but I think 3 months is usually a good check-in, at least to see if folks have an evaluation scheduled. So we'll go out to, and I'll also appoint Thurston County Public Defense.
Oh, Mr. Blunt.
Good morning.
Who
Good afternoon.
are you here for?
I'm looking for Ms. Shaw. She's with the city of Olympia. I thought with the city of Olympia, but there is no.
Good night.
I don't know where she's at. She's
Oh gosh, sorry. Yeah, I was looking at dates.
Yeah, I know, but there's no Olympia court anywhere. They just called Miss Scully. They said there's court going on. or-
Here, give me the cause number again.
I don't have the cost.
Oh,
Let me check with them.
okay, okay.
Thank you, Joe. Appreciate that.
Oh, okay, that's fine. If you want to just send it back.
Hey, sorry. Superior Court, which I just handled.
Hmm.
Oh, I think it's in 3.
Oh, is it?
Yeah, when they combine Olympia and Lacey, it's in 3.
I didn't even see it on
Yeah.
the leaderboard either, so
Yeah.
I was like worried. Okay, thank
We
you.
like to keep you on your toes. Yeah.
Yeah, of course, good luck out there.
Cheers.
Yeah, thank you. Mr. Concur, I appreciate your patience there at the county jail. We got some paperwork matters we're finishing up here, then we'll turn to you and your client. Appreciate your patience.
Yes, Your Honor. The jail notified me of the issue with Ms. Ferguson's order. Is that?
Yep, we're working on
Okay.
that, and then we're working on some competency-related matters for Mr. Schubert as well.
Okay.
So appreciate it. Got it. All right. Yeah, so I got Mayo's up now. I have to go into her case and see what those conditions were. No. Okay, so no UAs or anything like that. Okay. I'm unchecking so for Ms. Mayo, I'm unchecking the all prior conditions remain box, putting in conditions, no criminal law offense, not consume any alcohol, marijuana, or non-prescribed drugs, and then indicating a PR release. All right, and then for Schubert, there we go, thank you. All right, so Mr. Schubert, we're gonna go ahead and release subject to the DCR review. We'll go into excluded period of time, given the competency concerns, and set a competency review hearing, or go out to last week in October. Actually, what's there like a pretrial calendar we could use? 28th. Okay, it's a good time. All right, so October 28th at 10 o'clock, we'll set for a competency review hearing, kind of check in, see where we're at. And I did appoint Thurston County Public Defense as well. Okay, Mr. Concurry, over to you, the Thurston County Corrections. Again, thanks for your patience.
Your Honor, I'm here with Miranda Kilgore. She is on the calendar as Hannah Lachey Smith, which is an alias, and I don't believe that it's the correct date of birth on the court's calendar.
Oh, okay. Let's see. All right, so we have a Hannah Lachey Smith, and though Mr. Concurry, it's I missed the first name, but last name Kilgore.
Miranda Kilgore.
Miranda. Okay, and ma'am, middle name?
It says Watley on my license, WHATLEY. Original middle name is Lynn, LYNN, but I use my grandparents' last name, which used to be my maiden name, as my middle name on my license when they died.
And how about a date of birth, ma'am?
It's August 30th, 1983.
All right, so that Miranda Watley Kilgore, that's your legal name?
Yes. My sister is Hannah. I
Hannah
guess
Lachey Smith is your sister?
she's younger by 2 years.
That's the birth date we have is 2 years younger, I believe, as well. 85.
Yes.
Oh,
Yeah, the birthday we have is October 25th, 1985.
And it's August 30th, 1983 for me.
Okay, but October 25th, 1985, that's Hannah Smith's birthday?
Yes.
All right. Mr. Concurry, do you know how Ms. Kilgore here, looks like the warrant was issued for Hannah Smith and was served on Ms. Kilgore here. Warrant was issued by me, it looks like, July 22nd for failure to appear at an arraignment. We had the name Hannah Smith. Probable cause was established. Bench warrant issued for failure to appear for Hannah Smith. Were you able to speak with Ms. Kilgore about how she came to be arrested on that warrant?
I was already in custody.
You were, okay, you were already in custody. Okay.
Yeah, I've been here for about a month.
Let's see, DPA Will, if you would be so kind as to
yeah.
maybe bring up the police report.
Yeah, I have it up right now. It was a down file.
From
as
what I
well.
understand, they tell me it's an alias they have my name listed under.
Oh. Hmm. I believe the defendant was identified just verbally from what I'm reading. For the record, they did fingerprint the defendant when they brought her in, since it was a felony, originally a felony charge for Resberg.
Yeah, tell me.
All right, and Ms. Kilgore, so you say you've already been in custody. How long have you been in Thurston County Corrections?
For over today's the 30th day. My husband has been in here too, Marvin. Both of us for 30 days since the end of last month.
All right, so Mr. Concurry, are you able to maybe, so this is an issue with identification. It sounds like Ms. Kilgore here was, I think, at least the allegations are identified by fingerprint there at the jail, or whoever was served this warrant, and then the ID came back. Do you have any independent information as to identification? Other than,
Do I have any independent information as to?
well,
the
it sounds like
identity?
you've talked to her there. It sounds like she's saying, I mean, I don't have any reason not to believe you, Miss Gore. We're trying to just figure this out. So you've been in custody since the 30th.
Yes, sir.
Someone did a deputy talk to you there at the jail and say there's this and serve you a warrant while you were in
I never
custody?
knew about the warrant. We were arrested for complete other charges.
Okay. Well, a warrant was served today. So did an officer come up to you with a warrant and bring you, like, how did you come to be before? How did you come to be on this account? Okay.
He asked for me and they brought me to him.
Okay.
I think
Mr.
the
Kingery, might be
jail-
helpful.
The jail understands the correspondence between those names. So when I asked for Hannah Lachey Smith,
They brought me here.
they brought her.
My sister doesn't even live in this state. She lives in Georgia. That's where I'm from.
Okay, do we have so an officer whose name is, I cannot make out, Thurston County Sheriff's Office, today at 7:36 certified that they served the warrant on Hannah Smith. So again, did somebody talk to you about this warrant earlier today?
No. I didn't know a thing about it until about 11:30 when they called me to speak to him. Well, about 11 o'clock, because it was 11:30 when I got back to the dorm. Nobody handed me a warrant of any kind.
Okay.
I had no idea about
What are you being held on?
my other charges from the 30th. It may not have been the 30th, wasn't it like the 27th or 28th?
Are you being held on bond?
Yeah, I have a bill of like, I think 10,000, something like that, like my husband has. Marvin. Yes, sir.
All right, thank you, ma'am. You're free to be taken back. Who's Tally Smith, Miss Will? Is that a new?
It's a felony DPA.
Oh, it's felony DPA. Okay. I'm looking at the complaint for Mr. Hobby or the PC affidavit. I was like, did you guys bring someone new one? Okay.
Wish we could bring on Tally, but she's a little overexperienced for district court.
All right. Oh, is Tally helping with charging decisions during the transition and everything?
Yes, yeah.
Okay.
The DV felony attorneys right now are handling charging for a little bit longer.
Okay.
So,
Yeah.
Especially Sarah, who has Nicole's caseload, is
Right.
overwhelmed.
Okay. Is Isaac helping out at all?
I don't think so. No, but he's around.
I could see him declining that request.
Do you get to see him very often now?
Yeah, he came by a Lacey calendar recently, but I think that's because Patty Capone was there.
Oh, yeah.
Yeah. But yeah, I see him a fair amount
Do you guys still go out to lunch?
sometimes.
Yeah.
Yeah.
I always tell people it was the three musketeers, you and Zach and Isaac.
Yeah.
And they're like, really? That's that combo? Especially because Zach's now a defense
Yeah.
attorney. So they're like,
Yeah, it sure was.
yep.
All right. There at Thurston County Corrections, do we have Sir Jeremy Hobby?
Yes, sir.
That's correct, Your Honor. Mr. Hobby just told me something that I just need like 60 seconds about, because it's kind of a change in direction that we're going with this hearing. Thank you.
Okay, go ahead. Did you? I take it you spoke with
I
him
was the
earlier.
one spoken. Okay.
Okay.
I imagine there's a message coming my way.
Okay. And whenever you're ready, Mr. Concur, I see you came off mute. So when you're ready, just let me know.
Yes, Your Honor. Attorney Brocious is handling this matter.
Okay. Go ahead, Mr. Brocious.
Thank you, Your Honor. I have explained to Mr. Hobby his constitutional rights, and I believe he understands them. We are going to ask for appointment here, as he was both appointed in Superior Court and has state benefits and qualifies statutorily. And we were going to stipulate to probable cause for the purpose of this hearing only.
Okay, thank you. All right, so Mr. Hobby, as Mr. Brocious here may have explained to you earlier, we're here for what's called a preliminary domestic violence probable cause hearing. What that means is you've been arrested on allegations of assault in the 4th degree, domestic violence. You have not been charged with any crimes at this point, but today's hearing is twofold. Number one, to determine whether or not there's at least probable cause, which means a sufficient level of evidence against you, even though charges haven't been filed, to support setting conditions of release, and if so, then what those conditions are until we get to the arraignment. The state would have 72 hours to file charges, and at which point we would have an arraignment and those charges would be read to you. Based on comments from Mr. Brocious here and the screening form, I will appoint Thurston County Public Defense to represent you. So you'll have an attorney moving forward today, as well as at that arraignment, and if the case proceeds after that going forward. There's been a stipulation to probable cause, meaning that at this time, there's an agreement that there's at least probable cause for the allegations, meaning the court can set conditions of your conditions on your release. We'll do that next. For those conditions, I'll turn first to recommendations from DPA Will with the prosecution.
Yes, Your Honor. The state is requesting $20,000 in bail for this matter. The basis for that is the state is concerned for the safety of the alleged victims in this case, but also for the safety of the community. The defendant has a pending felony harassment charge out of Superior Court right now, and so he's in violation of those conditions of release for this case. As well, in this case, the allegations occurred in front of the shared party's children, all of the children, and it does, and the felony harassment also occurred in the presence of one of those children as well. So that is the basis for our ask for bail. As for conditions of release, we are asking for NCOs for the alleged victim in this case, which is the defendant's spouse, as well as for all the children who were, I believe, all present when this occurred. And we are also asking for a surrender of firearms. And of course, no new law violations.
All right, Mr. Brochus.
We would object to the bail and to the no contact orders with his children. I recognize that he has a pending harassment case in felony court, but right now the only charge in front of him from district court is just this yet to be filed assault case. Given I recognize he is on release from Superior Court, but right now the only thing, I'm sorry, let me collect my thoughts.
Sure.
The presence of children does not necessarily mean that he's more likely to reoffend. Again, this is just an allegation at this time, and given that's the only charge in front of district court, I don't think it rises to a level where $20,000 bail is going to be necessary in order to avoid being a risk of a substantial danger to the community. He has no warrant history. And so I don't think that under a substantial danger analysis, I think the no contact order with the alleged victim here is adequate to protect the community. There's no allegation he's ever violent towards his children.
Okay, thank you. Miss Will, I'm looking at the no contact order issued in the harassment felony case.
Those are different victims, not related to the family at all.
Okay. But did I hear there's an allegation that one of the children was present?
One of the children was present when that harassment occurred, yes.
All right, but not the subject of an order?
Not the subject of
it. All right. All right. What I'm going to do, Mr. Hobby, even though there's been a stipulation to probable cause, I've had a chance to review the officer narrative. I'm going to go ahead and read it again. It's not terribly long, and I'm about halfway through it again here. Give me a moment. Mr. Hobby, if the court were to release you without having to post bail, but subject to no contact orders protecting your spouse and the children who are present, is there somewhere that you feel you could stay, family or friends in the area?
Yes, Your Honor. I have friends I could get a hold of if I had access to my phone. Yes, Your Honor.
All right. All right. Well, Mr. Hobby, this is a close one. The state's asking for a significant amount of bail, which I understand. I think is a reasonable request. But I am going to release you on your own recognizance, subject to those no contact orders. Reason being, you are presumed, in addition to being presumed innocent. There are no charges at this point, but you're presumed released. That presumption of release only can be overcome if the court can find a significant danger that you'll violate a pretrial release condition intended to protect the community. Obviously, the big argument in that favor is that you're currently on pretrial release for felony harassment charges. Other than that, you don't have any history. There's no indication other than the allegations kind of swirling here that you wouldn't abide by pretrial release conditions, in this case intended to protect your spouse as well as those children, and otherwise comply with release conditions. So you're presumed able to comply with those conditions absent evidence to the contrary. I don't think that there's enough here, given that there's just one pending non-DV. Well, there's several counts, but non-DV harassment charges against you. So I think given all of that, I'll go in favor of that presumption of release on least restrictive means, which include only imposing bail as the most severe restriction. So for that, Mr. Hobby, you'll be released. Subject to the following conditions: to not commit a criminal law offense, to not possess a gun or a deadly weapon, and to comply with the no contact orders. We're going to set, as I mentioned before, no charges have been filed against you. We're going to set an arraignment. We're going to set that for, let's do Wednesday. It's a Wednesday morning. I know we usually do those at 1:30, but that's the DV calendar. Is the DV calendar pretty packed already? Yeah, we'll do 1:30. All right, so that's going to be Wednesday at 1:30 at Thurston County District Court. So that will be the arraignment. So if the state chooses to file assault charges against you, that's when those charges will be read to you. All right. And so what I'm also going to send over to you are the no contact orders and the order to surrender weapons. There are a couple of them here, so bear with me, and I'll just also let you know too. Talk to your attorney about this if you got questions. But from the police report, your wife was very clear about not being in favor of any no contact order, or really the case going forward, saying it would sort of be challenging with all the kids. So let me just warn you, the protection order it protects Star Hobby is the protected party. You're the restrained party. Even if she were to reach out to you wanting to talk about household issues, the kids, money, things of that nature, there's no exception to this point. You've got an attorney who can always ask the court for an exception, but just know, even if she engages you, that's not a green light to engage with her back. So I say that to you just because she was very clear about not wanting the no contact order and may be reaching out. So just talk to your attorney about that. But I just, given the number of no contact orders in this case and the situation, I think it's important to point that out here while it's going into effect. So you'll get a copy of the no contact order there at the jail. It does have what's called a civil standby. That means you can contact or you can go back to the residence to collect some personal belongings to take with you while the order is in effect. You'll need to first contact the Thurston County Sheriff's Office, their non-emergency line. They'll send a deputy to come meet you somewhere, and then we'll escort you to the residence and be there while you collect some personal belongings. So that is allowed. Again, if you have questions about that, you can contact your attorney. You'll also get a copy of an order to surrender weapons. It explains how you can either file what's called a declaration of non-surrender if you don't have any weapons. If you do have weapons, you'll need to surrender those to law enforcement, and there's instructions on how to do that, as well as what proof of surrender you'll need to then file with the court. All right. And so I've signed the first no contact order that also has that order to surrender weapons. I've signed that judgment and sentence that shows your next court date and the conditions. I'm going to go through and sign the other no contact orders as well. There's no need for you to stay in the booth for that. The provisions are all the same, other than who is the protected party. So we'll go ahead and let you be taken back while I sign these. But before I do, Mr. Hobby, do you have any questions?
No, sir, Your Honor.
All right. Okay. With that, you're free to be taken back. Make sure you get all the no contact orders before they do take you back. I'm counting 1, 2, 3, 4, 5. So your spouse and 4 children. So make sure you get a copy of all of those, read them, make sure you don't have any questions. Again, you'll have an attorney representing you. There's going to be you're probably going to get copies of also 5 orders to surrender weapons, just because they all come as a packet. I've only signed one of them. But that's a requirement in this case. I'm just not going to sign 5 orders to surrender weapons. All right. And with that, sir, you're free to be taken back.
Thank you, Your Honor. Bless you.
And is this Beth Built?
Yes.
All right, Ms. Built. Your patience is appreciated here. I've got a couple of documents to finish signing for that previous individual, and then we will turn over to your case.
Thank you.
Thank you, ma'am. Appreciate your patience. And oh, sure. Give us one more moment here. Okay. Ms. Built, good afternoon, ma'am.
Good afternoon.
It looks like we have your attorney, Attorney Milne on Zoom, as well as Counselor Rosero from probation. All right. I know we were here yesterday. I'm going to just kind of go through again where I think we are in the matter, and then Ms. Will or Ms. Milne or Mr. Rosero, feel free to correct me here. So Ms. Built entered a change of plea on a DUI back March 1st, 2024. Violation of probation was found on February 24th, 2025, specifically substance use evaluation and noncompliance with treatment. Was put on scram, sanction set. There were a number of scram violations in the interim period of time. And then on April 10th, 2025, there was a sanction hearing. I believe it was Judge Meyer ordered Ms. Built to turn herself into custody due to those violations, to have the sanction hearing in custody. And at the allotted time for that sanction hearing, Ms. Built was not in custody. There was no bail bench warrant issued. That was then served back on June 11th. That's all in the context of as well. There's a pending, looks like felony DUI, DWLS1, and no ignition airlock device out of Pierce County Superior Court from April. When we were back on June 11th, the court imposed $25,000 bail. Set this for an FTC hearing. This is maybe where folks can correct me. My review is, while there are new allegations, specifically the new law violation, I believe technically we're here also on a sanction hearing for that violation that was already found back on February 24th, 2025 for the substance use evaluation and treatment. We were here yesterday. I was reset to today. So with all of that said, we'll go ahead and hear first from Counselor Rosero. Attorney Milne, I'll turn to you last just so you have the benefit of hearing from everyone before we turn to defense. Go ahead, Mr. Rosero.
Yes, good afternoon, Your Honor. Yeah, like you mentioned before, she pled guilty on March 1st, 2024. Since then, probation has not got any evidence of substance use assessment completion or any kind of treatment. It's been actually more than 2 years. Instead of getting reports stating that she is in treatment, that she's trying to address her substance use disorder behavior, probation got new charges, like you mentioned, from Pierce County Superior Court, and also different warrants from another jurisdiction, like 5 Municipal Court and Jefferson District Court. She has shown lack of compliance, poor adjustments to supervision, multiple scrap violations. The court has tried to address her behavior with different alternatives like scram. She has not engaged in treatment, like I mentioned before. We have no evidence that she has completed any of her affirmative conditions. And like I mentioned before, it's been over 2 years. So probation thinks at this time that she's not interested in working with probation. So we are asking for her to serve the remaining balance of her suspended jail time.
All right. Thank you, Mr. Rosero. I'll hear next from the prosecutor who's here in the courtroom, DPA Will.
Yes, Your Honor. After doing some significant calculus, what probation officer has said is all correct by the state's calculations. On March 1st, 2024, when she was sentenced, or when she pled, I should say, 98 days were ordered to be served. She got 4 days credit from July 2nd to July 6th. And then later she was given 94 days credit from Pierce County by motion. And that totaled to the 98 days. Since she's been incarcerated now, by the state's knowledge, she has 44 additional days now credit for time served. So 44 days plus 98 days brings us to 142. And then we take that from 364, and she has 222 or 221 remaining. I'm sorry, my notes are very poor here. And so based on that, our recommendation would be to impose the remainder of that time and have the defendant serve on CDP to set her up for her felony DUI that she has coming down the line, potentially, of course.
Okay. All right. Thank you. Attorney Milne.
Thank you, Your Honor. Firstly, I would like to address Ms. Bilt's warrant status. She does have 3 outstanding warrants right now. However, I would point out that 2 of those 3 were accrued while she was in custody at Thurston County Correctional, so that wasn't a willful miss on her part. As for the substance use evaluation and follow-up treatment, while it is true that as of last year, probation had not gotten any sort of substance use evaluation from Ms. Bilt since then, she has been in touch with Pierce County Alliance on her release. They will put her on a scram bracelet and assist her with getting into a detox program. As soon as she completes that detox program, Ms. Bilt is fully set up to go into an intensive inpatient program at Sundown for a minimum of 28 days for intensive inpatient care. So, Your Honor, at this juncture, we would be asking, I understand and appreciate that the court will want to sanction Ms. Bilt for these allegations. However, I would be asking for 60 days, so 2 sets of 30-day sanctions for the lack of contact with probation and then the new charges. And I would be asking for credit for time served on those as well and for Ms. Bilt to be released.
All right. Thank you, Attorney Milne. And then before I'll Ms. Bilt, if you'd like to address the court too, you'll have that opportunity as well here. Also, just so we're all clear as well, is the role of the Pierce County Superior Court matter. A couple of things on that front. I do have a printout kind of narrative, a packet of the incident report. I understand that has Attorney Milne, have you had been given a copy of that, the incident report from Pierce County?
I have, Your Honor, yes.
Okay. I mean, I've had a chance to review it. Miss Built is entitled to a hearing on that. We're at a sanction hearing for previously found violations. So we could just move forward with the sanction today just on previously found violations. I don't want to reference the report too much unless Attorney Milne, you feel comfortable sort of stipulating to having received it and stipulating to a violation as found in the report. If not, I'm going to just set it aside because Ms. Built is entitled to a hearing after being given notice of the new law violation as a grounds for additional sanctions. And I don't want to include that in this hearing unless, Attorney Milne, you're comfortable moving forward with that as a stipulated violation.
Your Honor, I would stipulate to receiving the report. However, I would not be stipulating to the allegations contained therein.
Okay. All right. I'll go ahead and leave that out then. All right. So, Ms. Built, anything you'd like to say? I'm gonna impose a sanction today, and I'm not going to reference necessarily what's in Pierce County, other than you've been charged. I've got the charges in front of me, but we haven't had a hearing on that you're allowed under the rules. We're here on a sanction for a violation that has already been found for that lack of treatment. And so, is there anything you'd like to say before I impose a sanction, as far as how Attorney Milne there referenced some treatment you may be getting out of custody, that sort of thing? But you have a right to address the court. This is your time.
I'm not very good at explaining things, but I had just finished court, or I did like 6 years of treatment. And before I got, I did 6 months in Pierce County in 2024, and I did 6 years of treatment. And I was told that through the courts that Pierce County treatment would work for Thurston. I finished and completed the treatment for Pierce, and Thurston County, I'm pretty sure Thurston County told me I could do that through Pierce and it'd be okay with you guys. The only way I can prove it is on the docket in Pierce County that I finished the treatment.
All right. What case are you talking about out of Pierce County?
My first and second DUI.
From the 2018 DUIs?
Yes.
Yeah, let me take a look at this.
May I ask the dates, Your Honor?
Sure. So what I'm looking at now, it's Pierce County District 8ZC003525. I believe this was out of the 2 Pierce County DUIs. One ended up being a DUI conviction. The other was amended. This is, I believe, the DUI conviction. And it's got a sentence date of September 18th, 2019. All right, let's see here.
It will have to be after March 1st, 2024, if we want to count that.
Yeah, that's right. I'm just gonna take a look at the docket notes and see kind of what was going on there subsequent to the Thurston County DUI.
Still a lot of talk. Or should I wait?
Hey, Ms. Bilta, I'm not seeing anything in the docket notes since your change of plea in Pierce County referencing any kind of treatment compliance. I mean, they're really the only docket notes I see are probation violations for new law violations and sanctions. Are you saying you did treatment?
Yes, I completed it at
post-
sundown.
All right, was that like a residential, like a 30 or 45 day program?
Yeah. And then I did
there-
outpatient too.
Okay. Do you remember the years that took or when that took place?
I went to sundown in 2024 or 23. I'm sorry. I went to jail in 24. And I gave the paperwork to the Pierce County District Court judge for the DUIs. I don't remember, Butoff, or I don't know her last name. I don't remember it, but I finished the completement, or I mean, I finished treatment and it was completed.
In 2023?
I think it was 2023. Yeah, because I went to jail. I did 6 months in 2024, if I'm not mistaken.
Yeah. Okay. Yeah. See, the issue, Ms. Bilt, is that treatment you were doing out of Pierce County, that's all prior to the treatment requirements out of Thurston County for the Thurston County DUI. And so while I have no reason not to believe you that you did that treatment, I can't really count that as treatment done, as part of probation compliance here, because that was all before you went on probation.
When?
Okay. So, Ms. Bill, what I'm going to do today, I am going to impose the balance of the suspended time and refer you to the chemical dependency program. Now, what that means is Thurston County Corrections has a chemical dependency program that's in 3 phases. And phase 1 and 2, they're done in custody. There's lots of good programming. They've got, in addition to the classes, they got NA, AA, they help with reentry. There's all kinds of good programming. And then phase 3, if you're successful through the first two phases, oftentimes if you stay in communication with your public defender, there's a request for essentially a resentence for phase 3, which is intended to be done out of custody, and they have the capacity to do that via Zoom. You're on monitored, sometimes it's EHM, sometimes it's Scram, it kind of depends. But there's still a lot of supervision from the court, but you're allowed to do that out of custody for phase 3. And I think that's appropriate in this case, given the issues on probation so far. And while I'm not making any findings on the pending Pierce County DUI case, that that there's been probable cause found in that case, charges of DWLS1, driving without ignition airlock device, driving under the influence, that those cases have now been filed in Superior Court with a probable cause finding in context of 3 other DUIs, where we don't have any treatment compliance for this one. So I'm going to go ahead and impose the balance of time. So I'll impose, I agree with DPA Will here. I'm counting 222 days, which gives you credit for the 44 days I believe you've been in this last time. So that takes that into account. And then again, if you successfully complete phases 1 and 2, you are free to come ask the court to consider completing phase 3 out of custody, and talk to your lawyer about doing that. That's something that we do consider, which is how this program is frankly intended to be set up. So you're going to get paperwork at the jail showing the imposition of that time, a referral to the CDP program, and that compliance with CDP is a condition of probation. And so what that means is, if you do complete phase 2 and are allowed released, you're still going to be on probation, because completion of the chemical dependency program will still be a requirement of probation. So again, you'll have that opportunity if you complete those first 2 phases. All right.
Your Honor, so for the record, she will remain on active supervision?
Yeah, the way I understand this works, and if I'm wrong about this, I'm happy to be corrected, is that, well, I'm sorry, no. As of now, I'm taking her off active supervised probation.
Okay.
In the event that there's a request for essentially a resentence after phase 2, if the court agrees to release her, on conditions.
Oh, she
Then
will-
she's back on active supervised probation with the requirement that she complete CDP, so that whatever time is still remaining is then suspended while on active supervised probation. But as of now, she's being removed from active probation and monitored probation. She's being removed from probation's docket
All right.
and referred over to CDP.
Okay, thank you, Your
That's
Honor.
my understanding of how it works. All right. Ms. Bilt, do you have any questions, ma'am?
No.
Attorney Milne?
Nothing further, Your Honor.
All right. Ms. Bilt, I wish you luck. Again, if you get through those first two phases, feel free to contact public defense, contact the courts about a potential resentencing, and we can take a look at that. And going forward, though, ma'am, I wish you luck.
Do I contact my attorney to ask for that when it's time? Okay. Will you, can I call you tomorrow, Ms. Milne? I mean,
Tomorrow's Saturday, Miss Bilt, but I will be in the jail physically on Tuesday morning.
Okay, you'll see me?
Yes,
Okay.
I'll come and see you.
Thank you.
All right. Thank you, Attorney Milne. Thank you, Ms. Bilt. You're free to be taken back, ma'am, to go over that paperwork.
Thank you. Shall I get up?
Court is back in session. Commissioner Stillwell presiding.
All right, thank you. Please have your seats. And we are back. We've got Ms. Garcia. All right. And let's see. There at Thurston County Corrections, is this Pablo Vasquez Mendez?
El señor Pablo Vázquez Méndez se encuentra con nosotros.
Are you able to hear us okay over at Thurston County Corrections?
¿Nos pueden escuchar bien?
Sí.
Yes.
All right. Okay, so Mr. Vasquez Mendez, we're here for a warrant return on a failure to report to probation.
Señor Vázquez Méndez, estamos aquí por una orden de arresto ya que usted no se presentó con su oficial de libertad condicional.
You've had a chance to talk with Mr. Concurry from Public Defense.
Usted ya ha podido hablar con el señor Concurry de la Abogacía de Defensa Pública.
On Zoom, we have Counselor Rosero from Probation.
También tenemos al consejero Rosero del Departamento de Libertad Condicional en la pantalla.
The warrant was issued pursuant to a probation violation report.
La orden de arresto se puso ya que hubo un incumplimiento, se presentó un informe de incumplimiento de sus términos de libertad condicional,
Identifying a release from custody date of June 2nd.
se identificaba un día de libertad de estar fuera de custodia de junio 2
And a warrant request on June 5th for failure to report within that 48-hour period.
y una orden para su arresto fue puesta en junio 5 porque usted tenía 48 horas para haberse reportado y no lo hizo.
I'm going to hear first from Counselor Rosero.
Pero voy a escuchar primero para el consejero Rosero.
Good afternoon, Your Honor.
Buenas tardes, su señoría.
Mr. Vasquez, as you mentioned before, he was given 48 hours to report to probation upon his release.
Como usted mencionó antes, el señor Vázquez se le dio 48 horas para reportarse con los servicios de libertad condicional después de salir de estar bajo custodia.
On his last hearing, I was pretty clear with Mr. Vasquez and told him to report in person to probation.
En la última audiencia, yo fui muy claro con el señor Vázquez y le dije que tenía que reportarse en persona con el Departamento de Libertad Condicional.
He's on a deferred prosecution along with other cases.
Él está en un asunto diferido por la Fiscalía junto con otros casos que tiene.
He has 3 prior DUIs.
Tiene 3 anteriores de manejar bajo la influencia.
This morning he was booked for a new DUI.
Esta mañana lo pusieron en la cárcel por uno nuevo de DUI, o sea, lo hicieron todos los documentos nuevos.
That will be addressed as a felony DUI by Superior Court.
Y ahora en el Tribunal Superior se va a considerar un delito mayor DUI.
Along with this, he has multiple protection order violations.
Aparte de esto, él tiene varias órdenes por incumplimiento de órdenes de protección.
His adjustment to supervision is really pure.
Can you repeat that for interpreter? Interpreter not quite understood what you said, sorry.
His adjustment to supervision is really poor.
Okay. El que él ajustarse a sus términos de supervisión no lo ha estado cumpliendo básicamente casi nada.
There has been several warrants on him which make him a chronic absconder.
Ha habido varias órdenes de arresto puestas contra el señor, entonces es que él está prácticamente en búsqueda de manera crónica.
At this time, probation has filed an amended violation report, including his new charges.
En este momento, el Departamento de Libertad Condicional ha presentado un informe de incumplimientos enmendado, incluyendo los nuevos cargos.
And is recommending the court to revoke his deferred prosecution and serve the remainder of his suspended jail time.
Y estamos recomendando al tribunal que le revoque la acción diferida que tiene por la fiscalía y que lo deje pasar la sentencia suspendida que tenía de cárcel dentro.
If we don't resolve this case today, probation will request the court for Mr. Vasquez to be held until he resolves all his matters, and we can proceed with a sanction hearing.
Si no resolvemos este asunto hoy, el Departamento de Libertad Condicional va a pedir que el tribunal retenga al señor Vázquez hasta que se resuelvan todos sus asuntos y podamos proseguir con una audiencia.
Thank you, Your Honor.
Gracias, su señoría.
Thank you.
Gracias.
And before turning to defense, so defense has the benefit of both parties' input. I'm going to hear next from the prosecutor.
Antes de darle la palabra a la defensa, ahora quiero darle la palabra al fiscal para que así la defensa oiga de ambas partes.
Okay, go ahead, Ms. Will.
Yes, Your Honor. State will be echoing probation's recommendation.
Sí, su señoría, el Estado va a estar uniéndose a la recomendación presentada por el Departamento de Libertad Condicional.
We will be making an oral motion to revoke based on both the new law violation.
Vamos a hacer una moción oral para que se revoque tanto el incumplimiento por nuevo incumplimiento
And on the failure to comply.
y por no haber seguido los términos que tenía impuestos.
The state would be available to provide a factual basis for that revocation today.
El Estado va a poder dar hechos factibles para esa revocación con el día de hoy.
But I don't believe at this time defense has been provided with the new law allegations.
Pero no creo que la defensa ni siquiera ha recibido las nuevas alegaciones que tenemos aquí.
So we will defer to the court on the timing of the hearings.
Entonces vamos a darle la palabra al tribunal que decida el mejor tiempo para poner estas audiencias.
Thank you. All right,
Gracias.
Mr. Concurry, now I'll hear from defense.
Abogado defensor, le doy la palabra.
Your Honor, just a quick clarification before I make my statement. Does the court intend on carrying out the FTC hearing today, or is this just to address Mr. Vasquez-Mendez's release conditions with respect to his failure to comply allegation.
Su
You may need to cut your question up in a few parts there, Mr. Concurrent, for the interpreter.
That's okay. I got this one, but then I was gonna suggest. Entonces antes de contestar, tengo una pregunta para el tribunal. ¿El tribunal tiene la intención de hacer la audiencia de FTC hoy o estamos aquí solamente para lidiar con las condiciones de libertad del señor Méndez por haber fallado con lo que tenía que cumplir?
The court will not be proceeding with the failure to comply hearing today.
El tribunal no va a proseguir hoy con el fallo de cumplir los términos.
Mr. Vasquez Mendez is entitled to a hearing with notice provided beforehand.
El señor Méndez tiene derecho a una audiencia con notificación por ante el adelantado.
When in custody, either on a bail hold or a no bail hold, he has a right to that hearing within a 14-day period.
Cuando alguien está bajo custodia, con fianza o sin fianza, se tiene un derecho a una audiencia dentro de un periodo de 14 días.
And so the court's intention today is to primarily address custody status rather than the substance of underlying allegations.
Entonces, la intención del tribunal es lidiar con el estado de estar bajo custodia más que lo que digamos, lo que está llevando a las alegaciones que acaban de ponerse.
And with that, I'll turn it back to Mr. Concurry.
Le doy de nuevo la palabra al abogado.
Your Honor, Mr. Vasquez's probation violation is very much attributable to the disability that Mr. Vasquez deals with every single day of his life. He has limited vision.
Su señoría, el fallo de no haber podido reportarse con el Departamento de Libertad Condicional está basado principalmente en los problemas de discapacidad por temas de salud que el señor Vázquez tiene. Él tiene, su visión está limitada.
That limited vision results from Mr. Vasquez's diabetes.
Y eso es como resultado de la diabetes.
Because of that, and because he doesn't speak English, Mr. Vasquez was unable to find the place where he needed to go for his probation hearing.
Debido a esto y también el hecho que él no habla inglés, el señor Vázquez no pudo encontrar el lugar donde tenía que ir a reportarse después de la audiencia.
Those afflictions should not be confused for an unwillingness to engage with the court.
Estos problemitas no tendrían que confundirse con él no querer cumplir los términos impuestos por el tribunal.
While Mr. Vasquez does have some failure to comply warrants on his record,
aunque el señor Vázquez sí tiene algunos fallos y algunas órdenes de arresto por haber fallado en cumplir con términos,
he shows up for his court hearings with substantial consistency.
Él de manera consistente, bastante consistente, se presenta a las audiencias.
That is the information that's relevant to this determination of custody status.
Esta es la información que tiene relevancia para la determinación del estado de estar bajo custodia.
Mr. Vasquez Mendez should be released on his personal recognizance so he has an opportunity to engage with probation and get assistance for his disability.
El señor Vázquez debería tener la oportunidad de que se le deja salir bajo promesa para así poder involucrarse con el Departamento de Libertad Condicional y recibir ayuda para su discapacidad.
I'm referring him to Candace Garman from our office so that he can get assistance in dealing with the medical issues that have prevented him from fully engaging with probation.
Estoy refiriéndolo a él, a Candace Garmin de nuestra oficina, para que reciba ayuda en lidiar con los asuntos médicos que le han impedido a él involucrarse completamente con el Departamento de Libertad Condicional.
I take it from your comments that you're done, but when there's an interpreter, I like to make absolutely certain that folks have completed their point. So I just want to confirm you're all finished there, Mr. Concurry.
Imagino por su silencio que usted había acabado. Cuando hay un intérprete, quiero asegurarme que no es una pausa por eso.
Yes, Your Honor.
Sí, su señoría.
Thank you. All right, Mr. Vasquez Mendez, again, what we're going to do today is address whether you will be held in jail or not, pending a decision on alleged probation violations.
Señor Vázquez Mendel, con lo que vamos a lidiar en el día de hoy va a ser si a usted lo dejamos retenido bajo custodia o no, pendiente de la decisión de estos incumplimientos del Departamento de Provisional que se alegan.
The court is going to hold you without the opportunity to post bail until we have a hearing to address those underlying allegations.
El tribunal lo va a dejar retenido bajo custodia hasta que tengamos y sin fianza, hasta que tengamos la oportunidad de poner una audiencia para lidiar con esas alegaciones que tenemos pendientes.
What we'll do is you have a right to a hearing within 14 days.
Lo que vamos a hacer, pues, usted tiene derecho a una audiencia en los próximos 14 días.
I'm going to set a hearing for 14 days from now.
Voy a poner una audiencia dentro de 14 días.
If the parties would like to address your case earlier than that, there can be a request to put you back on the jail calendar within 24 hours notice.
Si cualquiera de las partes involucradas quiere hacer su caso antes, entonces se puede hacer una petición de ponerlo en el calendario siempre y cuando nos den un mínimo de 24 horas de aviso.
And for the record, Mr. Vasquez Mendez, I agree with Mr. Concurry that your failure warrants associated with failure to appear are fairly limited.
Para que conste en acta, yo estoy de acuerdo, señor Méndez, con el abogado Concurry, que usted haber fallado a presentarse y las órdenes de arresto asociadas con esas son bastante limitadas.
However, concerning to the court is that at this point, allegations are that the probation office has attempted to reach out to you many times without any real response.
Pero lo que es preocupante para el tribunal en estos momentos es que hay alegaciones de que el Departamento de Libertad Condicional ha intentado varias veces, bastantes veces, contactarse con usted sin tener una respuesta.
And the requirement to report to probation is now almost 2 months past.
Y ya han pasado prácticamente 2 meses desde que usted se tenía que haber presentado con los del Departamento de Libertad Condicional.
And the only reason you're back before the court is allegations of a felony DUI charge.
Y la única razón por la que usted está aquí en el tribunal hoy es porque existen alegaciones de lo que es ahora un delito mayor por DUI.
I think on balance, it is appropriate to hold you without the opportunity to post bail pending a hearing on those probation violation allegations.
Entonces, pues para poner todo en equilibrio, yo creo que lo más apropiado es retenerlo usted sin fianza hasta que tengamos la oportunidad de tener una audiencia para presentar esas alegaciones de incumplimiento de sus términos de libertad condicional.
All right, Mr. Vasquez Mendez, you're free to be taken back, and I believe you have court next in Superior Court.
Señor Vázquez, ya se lo pueden llevar. Atrás creo que tiene que estar en el tribunal de Superior.
And you'll receive paperwork there at the jail showing your next court date.
Y va a recibir documentos ahí en la cárcel mostrándole la próxima fecha de tribunal.
And you're free to be taken back, sir.
Ya se puede ir, señor. Gracias.
Gracias.
Okay, thank you.
Thank you, sir. All right, and we've got and thank you, Madam Interpreter. Ms. Garcia, I believe that's all for today.
Thank you. Thank you. Appreciate it. Bye-bye.
Bye. All right, Mr. Brocious, you've had a chance now to meet with Ms. Scalera.
Yes, Your Honor.
All right, so Ms. Scalero, I see you there on Zoom. All right. Give me a moment here while I bring up your case. All right. So we're here for an arraignment on one charge of assault in the 4th degree domestic violence. As you may recall, ma'am, from that hearing on July 21st, the state at that time had 72 hours to file charges against you if it chose to go forward. They have. Again, those are charge of assault in the 4th degree domestic violence, and today is the arraignment on that matter. We've got Mr. Brocious here in the courtroom. I'll go ahead and turn to him next.
Thank you, Your Honor. We're going to enter a plea of not guilty, and firearm proof to be aware in the process of getting
All right. All right, ma'am. So it looks like, the court will enter a plea of not guilty. Looks like you've got attorney Allie Milne from Public Defense who's been assigned to your case. Make sure to stay in good communication with her. We're not going to change any of the decisions that were made at that first hearing, so all conditions remain the same. Let's see. It sounds like Mr. Brocious talked to you about getting that firearm proof filed with the court. So either that declaration of non-surrender or proof that firearms have been surrendered to law enforcement. So we'll not make any decisions on that today, but just make sure you work with Attorney Milne on getting that submitted. The only other thing we're going to do today is set your pretrial hearing. And that's going to be on, all right, August 26th at 10 o'clock. All right, since you're not here in person, we've got, there's a form that I'm filling out and signing it's the same form you received at that first hearing. It just has the pretrial date on there. You'll receive notice of that hearing in the mail. Also, you can talk to Attorney Milne about that. All right, do you have any questions, Ms. Scalero? You're on mute, ma'am.
Sorry about that. No, I don't have any questions.
All right, and then we'll see you back at your pretrial hearing.
There's a declaration.
I haven't gotten a chance to send that yet. I was trying.
The declaration of non-surrender?
Yeah, I was trying.
Okay.
It was hard to do because I had to retype it. I couldn't copy and paste his
It's all right. We
email.
figured out with your we figured out with your attorney, Ms. Scalera.
Yeah, it's okay, Ms. Scalero. That's fine. Just keep working. I don't see in the court file yet, but that's not at this point. We're not.
Well, I was just in the middle of writing down the court date, and I spaced it when we started talking about. Can you say it one more time? I'm so sorry.
That's all right. It's going to be August. We said 26th.
26th.
At 10. August 26th at 10.
20.
And we've got Attorney Milne here on Zoom now too. So she'll be your attorney going forward here, Ms. Scalero.
Okay.
And Ms. Scalero, don't worry about that declaration of non-surrender. I signed that on your behalf on hearing that you didn't have any to surrender. So we got that filed.
Okay, thank you.
All right. Thank you, Attorney Milne. All right, so we'll see you back at your pretrial hearing, Ms. Scalero.
Okay.
You're free to log on.
August 26th. Thank you. Bye.
Thank you. And turning back to Thurston County Corrections, Mr. Concurry.
Your Honor, I'm here with someone with the last name of Ferguson. I don't see her on the calendar.
Yeah, me neither. Ms. Ferguson, do you have a, are you ready to do a person search? Are you able to give us your first and last name, ma'am?
It's Heather Ferguson.
Heather Ferguson? All right.
It could be Heather Mayo.
What's your date of birth?
4489.
One more time, ma'am.
4489.
All right, we're checking on your case here.
I had court yesterday, but I was sick.
Was that for Thurston County District Court?
Yes.
It was. I do remember speaking to Miss Mayo.
Yep, I talked to you yesterday.
Let's see. All right, hang with us, ma'am.
Thursday, yeah.
Ms. Wells, was a case dismissed yesterday, maybe? So, Mr. Brocious, you had a chance to speak with her yesterday?
I did speak with her.
Do you recall what the...
I believe it was a refusal. I think she got sick.
Okay.
It was a refusal.
Okay.
That's what I have as well.
Okay. On for an arraignment?
I don't think so. I think it was just a bench warrant return, Your Honor.
There's also a minutes indicated.
Okay.
And state has no objection to releasing her.
All right. We gotta find you in the system first.
It could be Heather Mayo or Heather Ferguson.
Under Mayo for us.
Under Mayo? Okay.
Yeah, M-A-Y-O.
Thank you.
And the case for us is ending in 6284. Thank you.
Okay. All right, ma'am, we're gonna make a judgment and sentence form for you here. And then, so I can bring it up on Jed. What's the case number? Thank you. All right, there we go. All right. Yeah, it looks like, all right, July 23rd, refusal for failure to appear pretrial. Let's see, reset. Okay, so it looks like what happened was pretrial was reset to July 29th and bail was set at $2,000.
I can't afford that.
Okay. State though, DPA Wells State's still okay with the PR
Yes, let me get the
recommendation.
Wrong one, sorry, give me a second. The last notes I indicate, Your Honor, we were okay releasing on her personal recognizance. That was back in March. So I will just echo that the state's okay with personal recognizance at this time.
All right, and it looks like Ms. Mayo was also released by the city of Olympia on the 21st. And then I'm guessing was, what happened? And then the warrant was served on the 22nd. So she was then brought over here to Thurston County Corrections to address this warrant, I think is what happened. Okay, ma'am, were you brought over just directly from Nisqually to address that warrant?
Yep.
Yeah. Okay. All right. We're going to go ahead. I'll release you on your own recognizance. It looks like you've been sort of passed back and forth between the jails here, and the more recent case, City of Olympia, the judicial officer there decided to release you on your own recognizance, and that was the last, in my view, sort of the last judicial officer to take a look at where you are, and then we're just addressing an older warrant here. So I think it makes sense to go with that more recent recommendation and release you on your own recognizance. So what we'll do is make sure we've got JNS for you. Oh, thank you. All right. So Ms. Mayo, we'll go ahead and release you on these as well. Pretrial is currently set for the 29th. That's just next Wednesday. That's when they thought you'd be in custody. And you've got Michelle Rose representing you out of the county. Do you know how to contact Miss Rowe?
Yeah.
You do? Okay. All right, good. All right, let's see where Olympia is.
Ms. Rowe, do you have her contact information?
Oh, I thought it was on there.
No, because she's a different attorney than.
No, I don't. I'm sorry. Can I get her number?
I can get it for you.
You got that, Mr. Concurry?
Yeah.
Okay. Does she have any particular dates? Michelle Rowe that she uses for county cases? Okay, Fridays. All right. So, Ms. Mayo, it looks like your next court date in Olympia is also a pretrial hearing, and that's on August 12th. What we'll do is we'll set a hearing for this case and for the county that same week. Ms. Rowe typically has Fridays. So what we'll do is we'll set your pretrial hearing for Friday, August 14th. So then we'll also strike the pretrial hearing for the, next week.
Wait, what?
So your next, so you got a couple of dates here, ma'am, to juggle. The court date here for this case is going to be Friday, August 14th.
Okay.
And that's going to be at 10 o'clock. You're going to get paperwork at the jail too with this information. And that's going to be for your pretrial hearing. And then not before us today, but the matter that you were released on out of City of Olympia when you're at Nisqually, your next court date there is August 12th at 10. So we're trying to keep it in the same week for you, but we unfortunately have to set them on different days.
Okay.
All right. All prior pretrial release conditions remain the same. I don't have those in front of me, but just make sure you comply with those conditions, ma'am. You'll be released on this. And again, pretrial hearing is going to be August 14th at 10. Make sure to stay in good communication with Ms. Rowe. And with that, you're free to go.
Thank you.
Thank you. Thanks for your help, Mr. Concurry, getting her Ms. Rowe's information.
Of course.
Yeah, thanks.
So what's this one for then? That's for.
Getting that together. Okay, Mr. Brush, you know that the Jessica Maestas was dismissed?
Yes.
Okay, all right.
I also want to address Kenneth Shumpert, number 7 on the calendar. He is a refusal.
Oh, okay.
And we are filing today's episode.
Oh, all right. Thank you.
Mr. Schumpert?
Yeah.
All right, Kenneth Schumpert was here for an arraignment, 26M00376, for one charge of reckless burning, second degree. So it appears to be held by Superior Court.
Use a down file.
Oh, okay.
That is correct, Your Honor. It was originally charged as arson, too.
Oh, okay. All right. All right. First thing to do is so my view on these situations is the court can really only impose bail or not set any other conditions.
When a defendant says they're innocent, should they still accept a plea bargain? That difficult question brought one courtroom hearing to a complete stop. Alexander Thornton appeared ready to resolve his felony case through a negotiated plea agreement. The judge began by asking a simple question. Did he commit the crime or not? Instead of giving a clear answer, Thornton hesitated, suggesting that his decision depended on how much credit he would receive toward his sentence. That immediately concerned the judge. She explained that guilty pleas cannot be based on getting a better deal. They must be based on accepting responsibility for conduct that actually occurred. Recognizing the uncertainty, the judge paused the proceedings and allowed Thornton to meet privately with his attorney. After the break, defense counsel created a clear record in open court. He explained that prosecutors had previously offered a 3-year prison sentence as part of a plea agreement, and that Thornton had originally agreed to accept it. Together, they had reviewed the paperwork, discussed the possible punishment, and prepared to resolve the case through a guilty plea. But once they entered the courtroom, everything changed. Thornton unexpectedly told the judge he was pleading not guilty instead. The attorney then explained what happened during the private conversation outside the courtroom. He told Thornton that if he truly believed he was innocent, he could not ethically plead guilty simply to receive a lighter sentence.